Correct.
Or if not so, what is elder law when you say that?
That's a great question. Elder law is a very broad spectrum of services we provide to families and individuals that are needing care above and beyond what you normally would expect in terms of health care.
Okay.
And it could also include people that have special needs that are not elderly. So, for instance, someone that's in their 20s.
Mental incapacity
or
or
physical
disability?
incapacity, something where they're not going to be able to manage their own care.
Okay.
One of the standards we use is that Social Security has defined what disability is. And when you have a disability and you have it prior to a certain age, the Social Security Administration will issue a letter to you explaining that you are disabled. Okay? And that disability will allow you to get certain benefits, like either Social Security Supplemental Security Income, SSI, or Social Security Disability Income, SSDI. SSI comes for people that are otherwise disabled prior to their working age. Let's just use that instead of a number. And then if you've had work and you've worked during your lifetime and then you become disabled, then the SSDI becomes the benefit. Okay. So I'm not so much working with people that have SSDI, more the SSI for the special needs. Okay.
So on the DI side, would that include, and probably thereby why you don't work with that, a fireman who's injured on the job, or someone who's injured in a factory job or at work?
We just haven't reached the point where what we do, other than the estate planning side, where that makes sense. Now, there may be a day when that person that's on SSDI is going to need to prepare for long-term care benefits because that injury has continued to progress and become more problematic, and they're going to need more care. If that day comes and their other income and assets and insurance don't cover it, they may need Medicaid benefits.
Okay.
There are ways to plan for that ahead of time. And I don't want to get into that in too much detail right now. We can talk about it a little bit later, but I want you to understand conceptually that that person has to reach a point where long-term care, either at home or in a nursing home, is
maybe their only
necessary.
option. Yeah.
It may be the option that they're drifting towards.
Okay.
Whereas with someone that has SSI, that is special needs, we're going to do potentially some planning right away. So we may either create what's called a testamentary special needs trust or supplemental needs trust, which means that on the passing of the parents of that person, we would create a supplemental needs trust that would allow the money to be used for their benefit, but at the same time, it wouldn't count towards their own income needs. So it wouldn't interfere with their federal or state needs-based aid. So our goal there is to make sure that that person can still get aid, but also has additional monies for extras. Things like vacations or education or whatever is not covered by any of those other benefits.
Or they may have to have some sort of benefactor or overseer of some sorts, right?
Generally, it's going to be a trustee that's going to manage the healthcare side.
Okay.
There's going to be a guardian that's going to manage their
finances and housing.
Well, no, the guardian is really going to manage their healthcare, their person.
Okay.
The trustee is going to handle finances, and there may be somebody that's named as a conservator or whatever, again, for money that's theirs, that's not covered under the trust that the parents created. We can also create a trust during lifetime. Okay, we call them inter vivos, during lifetime. So that lifetime trust, it can be supplemental needs, and generally speaking, it's going to be one of two types. It's going to be first party trust, which is one where it's that incapacitated person's or disabled person's money. And generally speaking, that's going to be if the person for some reason won an award. Our friend James Avery wins an award for one of his clients. And it's a really large amount of money, but that person is now disabled. The court can order that that property be incorporated into a first party supplemental or special needs trust so that that property can be used by the trustee to help that person who's now receiving federal and state needs-based aid. But at the same time, eventually, that state and federal aid will be repaid by that trustee, and anything's left would go to the family. There's a third-party trust where...
So is that like a draw against that? Would it be, in other words, if I'm receiving, and I'm going to speak very hypothetically because I don't understand anything else, but if I'm receiving $1,500 a month in government care and assistance, Yet my trust has been set up to where I receive $2,500 a month for 20 years. And when that overlaps, or when I am deceased, and there's a total of $10,000 I've received from the government, and I've still got 3 more years on this trust where I'm going to bring in an additional $25,000, does the government receive that $15,000 they paid into what my supplement was?
Here's what happens. So suppose we put $250,000 into this first party trust for the benefit of this person that was injured.
Okay.
Injured. That's a good word, isn't it?
Yeah, injured. It's a new one.
Injured, yeah.
We'll put it on Wikipedia.
Okay, we'll go for that. I have to tell Jim about that one. Hey, Jim, have you had any injuries lately?
Yeah.
So our goal here is to understand that that first party trust is not going to be counted in terms of income or assets for that special needs person.
Okay.
So they're going to still get the federal and state needs-based aid. When they die, and all of the distributions from this have occurred for that person, okay, and they were all legitimate, okay, so there were no impacts to that person's special needs benefits, then whatever's left, the government's going to go, okay, here's our bill. And they're going to go to the trustee and say, you are required under the terms of the trust to reimburse Medicaid, Social Security, whoever it might be. Okay, and here's what the bill is.
And they always get their money back, don't they?
They do, and that's the whole idea. The money should go back to them because they provided the benefit. So our goal is for that money to go back to the government. If anything's left, then it can be distributed in accordance with the remainder portion of the trust to family members or whoever it might be.
Okay.
Does that make sense?
Mm-hmm. As much as it can for
as much as it can.
Hearing it for the first time.
It's a little short time, and I don't have a board up in front of me to show it to you. So
I get the gist of it, and especially since I'm not in any part of that sort of situation on either end of it, then I think I have a very firm understanding of what that might mean. And certainly I would think that your description to anyone who is involved in this situation like that, whether they're the guarantor for this individual or the individual itself, probably has a firm understanding now of what you mean by those things.
I certainly hope so, but my goal is to help as many people understand what this means and how they can use that to benefit themselves and their family, and prevent all of their assets from being used up for the benefit of someone, so that it can be used for the benefit of the rest of the family. That's why we do this, is to protect the legacy.